while we're waiting for it to come up, I'm Lainey Feingold. This is the Digital Accessibility Legal Landscape for AxCon 2024. I have a big notice on the front page that this is not legal advice. There won't be anything I say that will be legal advice, so please don't count on this to be legal advice. I'm on LinkedIn, and there's a lot happening in the legal space. I write about a lot of things on my website. My website is lflegal.com. I have a mailing list on the contact page, but honestly, last year, I think I only sent one email, maybe two. So really the best way to keep up with what I know is I usually post everything on LinkedIn, a little bit less on Twitter and Mastodon. So that's where you can find me in between legal update sessions. And the other thing about the title slide is there is a dolphin smiling in the background. Dolphin is my spirit animal, my icon, my alternative to being a shark. I am a disability rights lawyer. I've been in the digital accessibility space since the mid-1990s. I really believe in collaboration, especially in the space of digital accessibility. I practice law that way. I haven't for many years filed a lawsuit. My process is structured negotiation. It's a process shared by others in the accessibility field. Even though lawsuits are important, collaboration, in my view, is always worth a shot. So the dolphin represents that. We'll talk a little bit about the dolphin if we have time later, but if you see the dolphin, you'll know why. Okay, so let's get started. Today's roadmap. The road in the roadmap picture is Northern California with redwood trees. I picked this for the roadmap picture here because I am in Northern California, and I want to tell everyone that today, when I turned on the computer and looked out the window, there was a rainbow. So I think that bodes well for today, for this presentation, and for AxCon, and for all of us in accessibility. What are we going to talk about today? What is digital accessibility? Accessibility as a civil right. What's happening in the United States, what's happening now currently in terms of laws and regulations, what's on the horizon, how are the laws being implemented, what are some of my favorite things happening, and what are some of my least favorite things. This is a reminder to say, this is an update. So much is happening that we can't possibly talk about every case, every negotiation, every law, every regulation. So that's why I have this, my favorites, my least favorites we'll talk about. I want to give a quick shout out to the global landscape when I'm done with the US. And if we have time, we'll talk about how do we talk about the law. So I like to start with what is digital accessibility. And what I want to say about that is whatever your role, whatever brought you to this session this morning, that is digital accessibility. Some of you are policymakers or testers or designers or UX professionals, researchers, web developers, so many things. Sometimes I don't even like to make a little list because I'm leaving so many of you out. I'm a disability rights lawyer and a negotiator and an author and a public speaker in the accessibility space. We're all working so hard in our little areas that I think it's really important when we talk about the law to remember what the big picture thing is that we're doing here. So that's why I like to start with what is digital accessibility, even though we all somehow know that because we are here at AxCon. So what is digital accessibility? My shorthand answer, one of many we'll talk about in a second, is disability inclusion in all things tech and the intentional practices that make inclusion happen. And that intentional practice part is what we are all doing. I have an engine, an old steam train engine, as a background picture of this image because I think of accessibility as the engine that drives disability inclusion. Too often people think about the law as something to be afraid of, or a checklist, or, oh my God, we got hit by a lawsuit, we're trying, something negative. But if we hold in mind that digital accessibility is the engine for disability inclusion, I think it's motivating for ourselves and it helps us use the law to advance digital accessibility. I also think of digital accessibility as I didn't set my timer, so now I'm going to be a little bit off. So I'm hoping I will be forgiven for that. Sorry. Digital accessibility is a door and a bridge. So the first picture is a door really closed up and locked. The paint's peeling, hasn't been open in forever. And really, our work in digital accessibility is to open that door for people with disabilities. So the first picture is closed up door with peeling paint and double locks. And the second picture is an open door with the light streaming in. Everything we do, we are making decisions. We have choices. We can advocate for opening the door. We can be a door opener. Bridge. This is the Golden Gate Bridge, which I see out my window here, which had the rainbow this morning. We're bridge builders because on one side of that bridge is all disabled people all over the globe who cannot access technology on the other side without accessibility. And we use the word digital accessibility. When I started in the space, we talked about web accessibility. The law is involved in all aspects of digital, web, mobile, workplace software, learning systems, classroom tools, starting to be cases on virtual reality, artificial intelligence. So we can be a bridge builder, connecting people with disabilities to technology, all technology. Accessibility barriers are stairs. This is a picture of the Capitol Crawl, which I invite you to investigate if you're not familiar with it. It was an activist action in the run-up to the ADA. And this image, which is by a movement photographer named Tom Olin, shows two people, one crawling up backwards on his butt, the other facing forward, crawling up. People left their wheelchairs at the bottom of the Senate steps to demonstrate what the barriers were like, why we needed the ADA. You know, too often because of certain type of lawsuit that's being filed now, people feel, oh no, an ADA lawsuit, there's something from on high that we have to do something. Why do we have to do it? And the ADA is a law that was passed because of the activism of disabled people for inclusion. And we are ramp builders if we are involved in digital accessibility, because today's barriers are yesterday's steps. Digital accessibility is privacy and security for disabled people. Any technology system that was designed for independent use is broken when there is no accessibility and people with disabilities have to get outside assistance when none would be needed if things were accessible. So digital accessibility is privacy and security. It's essential to diversity, equity, and inclusion, not just because disability is a characteristic that is part of the human existence and should be included in diversity, equity, and inclusion, but because all the categories of DEI, race, gender, LGBTQ, all the categories include people with disabilities. So essential to DEI, digital accessibility is an ethics issue because it impacts the autonomy of people with disabilities, the privacy, fairness, justice. The work that we're doing, we are involved in ethical technology, and digital accessibility is a civil right. This is another picture from the run-up to the ADA, and it's a march. The first row are people with disabilities, and one of the women in a wheelchair has a sign that says, access is a civil right. And that, another Tom Olin photo. That's because without accessibility, there's no participation. There's no inclusion. There's exclusion, which is why I have the word exclusion double strikeout. And there's no communication. Digital accessibility brings the reason you have a law here, the reason you have a lawyer here kicking off, you know, an accessibility conference is really because of this. And if you have to go now, this is the main message. Digital accessibility is a civil right, and those civil rights are baked into laws, which is why I have the raw cookie dough, because the cookie dough is delicious. Civil rights are important and valuable, but without the laws, the cookies are not yet baked. So civil rights, when you think about the law, think that first, because civil rights are about people's participation, and that's what the laws are based on. So I like to start, besides the dancing dolphins in the background here, jumping out of the water, with this quote: the legal framework gives us permission to dream what is possible. I love that. I heard that at the Ability Summit in 2021, spoken by Lizzie Kiyama from Kenya. A shout out to the Ability Summit, which is coming up on March 7th. Microsoft gives us 5 hours of beautiful accessibility content and people to learn from. So really invite you to participate in that. If you're at AxCon, you see the value of this kind of gathering. I think you'll feel similar with Microsoft Ability Summit. So the legal framework gives us permission to dream what is possible. We have a very strong framework in the United States. So first, let's talk about what's the US framework existing federal. I put a picture here which shows a map of the United States divided into 12 different districts, which are 12 different colors. And that's to say it's one country, but the federal court system is divided into what they call circuits. So I'm in California, that's the 9th Circuit. Every circuit has at least one district court. Bigger states like California, I think we have 3. We have the Central, the Northern, the Southern District. So every circuit can have different views of how the law should be applied. So there will be links dropped during this talk into the chat. And afterwards, the links will be on the session page. So there's a lot of content, which is why I do the link list. You can dive further into these things. Anyone curious about how the federal system works, there's a link for that. So within that federal system, we have the courts that interpret it. We have the Americans with Disabilities Act, laws and regulations. Why does the Americans with Disability Act apply to digital when it was passed in 1990? Because of 2 key principles. One is anti-discrimination. The ADA is about not discriminating, not excluding disabled people. So we cannot have technology, websites, mobile apps, kiosks, voting machines, electric vehicle charging stations, anything digital discriminates if it's not accessible. The ADA also talks from the beginning about effective communication. There is no way to effectively communicate digital content if that content is not accessible. So this is why the ADA applies today and is being used today to protect the civil rights of people with disabilities in the tech world. We have Section 504, which is about federal government spending. Bottom line, federal government, if you get money from it for your university or your transit system or whatever, you can't exclude people. 508 is the federal procurement law. You're selling to the federal government, you got to be accessible. The federal government has to treat disabled employees with fairness, without discrimination. The CVAA, the 21st Century Communication and Video Accessibility Act, is another part of the strong framework that gives us here in the United States permission to dream of an inclusive world. Is about captioning and audio description and inclusion of people in communication systems. We have the Air Carriers Act, a special law for airlines that requires websites and mobile apps and airline kiosks to be accessible. We have the Affordable Care Act. There's a section 1557 of that, which talks about technology for healthcare providers. Just want to say a quick thing about WCAG, the Web Content Accessibility Guidelines on these. Some of these laws incorporate the Web Content Accessibility Guidelines, like Section 508 does, the Air Carriers Access Act does. Other laws like the ADA do not yet incorporate the WCAG. However, courts in all these colored places on the map here, they use the Web Content Accessibility Guidelines to determine, oh, was there discrimination? Was there not? One other thing about this whole district, this week, there was a court in Pennsylvania. Someone tagged me, thank you to that person, on LinkedIn. When this case came down, somebody else sent it to me, that a Western District of Pennsylvania said, if you're digital only, if your business is web only, you can't bring a lawsuit under the ADA, which is important to know, but no one's building a website just for the Western District of Pennsylvania. So it's really important when you hear about all these cases, and there are a lot of them, to remember that there are many parts of this country, many district courts, circuit courts that say, yes, web-only businesses are covered. Some say no, web-only businesses aren't. But if you're an organization, you're not building your technology just for one court district. So just want to say that about that. The US framework, another map, because not only do we have different districts and different circuits, all those laws that we have federal, many states, and this map is map of the United States, every state in a different color, many states have their own laws that are part of the foundation, that are part of the framework, that protect the civil rights of disabled people. There are links that will be dropped in on this slide for all of the different state laws. So this is like a bird's eye view that many states have anti-discrimination laws, just like the Americans with Disabilities Act. California and New York, even New York City, some constitutions have requirements. So many states have anti-discrimination laws. Many states have state-funded laws, just like Section 504 in the federal. They have state purchasing laws, just like Section 508 in the federal. If your state is going to give you money, you can't discriminate. If you're going to sell to your state, you have to sell accessible. There's a law in Maryland, a K-12 procurement law, which as far as I know is the only one in the country. Please let me know if that's not true. I should say right here that so much of my ability to do these updates, write these articles, depends on the kindness of friends, colleagues, and strangers like each of you on this call who send me, oh, have you heard about this case? Have you heard about this? Because I'm a one-woman show. I have worked out of my house since 1996. I have no staff. I depend on hearing from people about what's happening in their state. So this Maryland K-12 procurement is an example of that. I invite you to send me things as appropriate. K-12 procurement was, you can't buy tech for K-12 students. Again, civil rights of students to get information without it being accessible. Maine has a really interesting state. I like to read this. I have everything tagged in alphabetical order, I think. Yeah, Maine has a law that's for digital information services developed, procured, or provided by the state of Maine. And there's a provision in there that really reads like a law that says, don't go for a quick fix. The expectations are that accessibility and usability for all current and potential users will be considered, and that accessibility will be addressed natively without relying on third-party products to improve accessibility that could potentially interfere with inclusive user experience. So we'll talk a little bit about overlays later, but this is an example of a law that is specifically referencing it. State agencies, Colorado, Massachusetts, California, Rhode Island just introduced something last year, are making specific laws that talk about that the websites and the mobile apps of the state government and the state government agencies have to be accessible. If you're selling to those states, has to be accessible. It's interesting to me because the Americans with Disabilities Act has long said that state and local governments have to have accessibility. So I really love these laws because they're an added, yes, we're proud of it and we're going to do it in our state, but if your state doesn't have one, you still have to make websites, mobile apps accessible because it's part of the Americans with Disabilities Act. We're going to talk about that in a minute too. So law means remedies. The laws aren't just things on the book. They give rights to people to get remedies. So this is why I have a tea bag, because tea is a nice remedy. Legal remedies, tea is a nice remedy if you're sick, but legal remedies can be burdensome. So we don't have time to parse every law and look at the remedy under every law, but in terms of the big framework, the remedies are a court can order you to fix barriers, fix systems. It can be court oversight for many years. The Department of Justice can issue penalties, require penalties be paid up to $150,000 if there's been more than one incident, although I'm not familiar with fines in digital accessibility running that high. If I'm wrong, I hope someone will put it in the chat. Some of these laws have requirements that you have to pay the disabled people who bring the case, not the ADA. The ADA doesn't have a provision of that, but some states do, like California, New York, which is why you see so many of the lawsuits in those places. You have to pay the disabled person's lawyers, because in civil rights cases, that's how it works. And you have to pay your own lawyers. So this is why I say be proactive. Be proactive around the law, because if you're reactive, you may have this whole list. And if you're proactive, you're going to fix the barriers and not have the whole list, which is why the rest of the list faded out when the fix of the barriers came up in the contrast color of celery against the blue background. Fix the barriers, fix the systems, start now. Okay, so where are we on the roadmap? The picture for this roadmap is the East Coast sunrise, because I already had the West Coast, and this is to remember that all over the United States, although it may be interpreted differently, the ADA applies and the other federal laws apply, and there's laws in states across the country, from the East Coast, beautiful sunrise against the ocean, to the West Coast, Golden Gate Bridge. Civil rights are baked into laws. So we talked about what is digital accessibility, why it's a civil right, what's the landscape, what's the current laws. Let's talk about what's on the horizon. A lot is on the horizon. And I like talking about what's happening and sharing what I know about it. And please, again, drop into the chat or email me if you know about something I'm not about to mention. But the current framework is really strong. And the current framework that we just talked about, even if nothing was on the horizon, provides us with a strong foundation, but the things on the horizon make that foundation stronger. So the proposed accessibility laws, there's the website and software apps law, which is a federal law, first introduced, federal proposed law. It's not a law yet. First introduced in 2022, reintroduced last year. I have an article on my website about it, and the actual pending legislation, as well as the article on my website, will be dropped into the chat and will be on the session page later. And I thought I had a little, yes. I think the main thing to know about the proposed legislation is this. In the FAQs, does the Americans with Disabilities Act already apply to websites and application? The answer is yes. Yes. The Department of Justice has long held that the ADA covers websites and other technologies that are critical to accessing a business or agency's services and facilities. So yes, we need this law. We need it to be, basically it strengthens the ADA, and it also goes, this is also from the FAQs, the bill goes beyond the ADA to cover commercial providers who design, develop, and modify websites or applications to certain covered entities, beyond the ADA to cover commercial providers who design and develop websites and other applications. So this is something we're watching. I have an article on my website. When you find an article, you can see that I have a way to update it so everything stays together in the same place. And as I learn about these things on the horizon, as things develop, if it becomes law, you'll be able to find it on my website. So that's one of the proposed laws. There's another law for the CVAA to update it. They changed the name in the new law, Communication, Video, and Technology Accessibility Act, the CVTA. And that will, again, strengthen the CVAA. Both of these laws talk about emerging technology, which the way the law works, when they talk about emerging technology, it's usually well emerged, should be the word, but there's a community website, and that's in the links that you can learn more about the CVTA. Both these laws are very heavily supported by disability rights organizations all over the country. California has a bill pending. It's called 1757. A lot of people ask me about it, so I put it on here. It really is just a way to clarify and strengthen California's law around web accessibility in mobile app lawsuits. So it didn't pass last year. I don't know if it'll pass this year. I think the thing about proposed laws, it's really important to kind of keep them in your mind, to know that all the laws are trying to move accessibility even further, but don't wait for the laws to work on accessibility in your organization. So we have possible accessibility regulations, so many of them, which is why I decided to do that link list, because you can't possibly in 40 minutes go into each of them. But the Department of Justice is trying to pass web and mobile accessibility regulations for Title II. They're not final yet. There's kiosk regulations that the Access Board is trying to pass, call them self-service transaction terminals, or kiosks, also trying to pass. Here I put in my picture of the woman sitting on an old-fashioned trunk at a train station, looking down the line, waiting for the train. We can't wait for these things. If you read my articles, you'll see that I started working on these, as did many other people, in 2010, which is now 14 years. We still don't have these regulations. I feel confident that the Justice Department and the Access Board and the Biden administration want to get these things out. We'll have to see what happens. The healthcare, the Health and Human Services is trying to update Section 504. The Affordable Care Act has an update on the horizon. FCC has proposed rules about video conferencing, even though it's already required that video conferencing, like we're all on today, has to be accessible. Like the web and mobile for Title II, it's more about having specific standards. So I want to say, I know it would be so helpful to have specific standards, to have WCAG just wrapped in there so there doesn't have to be any conversation about it. Like my friend Chancey Fleet says, it's like the plumbing code. We should just know it's there. And if you're going to be a good plumber, you follow the plumbing code. If you're going to be a web developer, designer, you follow WCAG. But we don't have that yet. We can't wait because the anti-discrimination law, the civil rights laws already require accessibility. Department of Education is trying to put out new regulations. They said they were going to. We don't see those yet. There's even going to be EV charging station rules that will have obviously a digital interface. We don't have those either. So I'm tracking all these. You can follow me on social media, LinkedIn, to try to keep up with it. I try to keep up with it, but I also don't wait for it. So there's my don't wait sign over the poor woman in the rain with the umbrella looking for the train. Okay, but the United States federal government agencies do more than issue regulations. So in this time when it's so hard to get the regulations out for whatever reason, I have a slide that says beyond regulations, more U.S. agency guidance. And the image here is of a medical professional in a telehealth call. Is a Black woman taking notes. She's the doctor. And the person on the screen is a Black man who does look kind of sick, which is why image for the telehealth provision. The DOJ and the Health and Human Services have telehealth guidance issued in July of 2022 about the importance of accessibility. You talk about privacy in healthcare. It's one of the key places where privacy and accessibility intersect. So the DOJ and the Health and Human Service telehealth guidance. There's DOJ and EEOC artificial intelligence hiring tool guidance. So important to avoid using AI hiring tools to screen out people with disabilities. That's also from 2022. President Biden has done some really good artificial intelligence executive orders, a few of which specifically reference disability and the avoidance of disability discrimination in AI tools. These are all going to be in the links list. And the Dear Colleague letter, Department of Ed and Department of Justice from July of 2023, where they talked about the importance of digital accessibility in higher ed and said they wanted to do regulations because the regulations are old. But until we have regulations, this Dear Colleague letter, which is kind of a way of doing guidance in the federal government, is really important to look at. So that's what I have for the landscape current and what's on the horizon. Let's talk about implementation. So without implementation, the cookie dough is still raw. As we can see, same picture, so yummy, but really shouldn't be eating so much raw cookie dough. We need implementation to bake the cookies. So how are current laws and regulations implemented in the United States? First question, who and how? This is an image of a student, a Black student speaking sign language, using sign language to communicate. And I chose that picture because people with disabilities are the front line of enforcement. And I say that because too much of the law is just thought of like as a lawyer thing or a government agency thing. But in fact, if you have an organization and you get calls in, you may call them complaints. I would call them opportunity for feedback that say things like, I couldn't find it. I couldn't hear it. I couldn't understand it. I couldn't see it. These are all wake-up calls that there may be accessibility issues someone trying to enforce. No one is going to call up most people and say, there's a WCAG violation on this page of your website. No, this is about the engine of disability inclusion. This is about the disability side of usability. So people with disabilities, disabled people, are frontline implementation. Government agencies, lawsuits, and structured negotiation, which is the way I've been practicing law, are the other primary enforcement mechanisms in the United States. So some of my favorite implementation actions, which I have fireworks in the background because they're good and they're things to celebrate. So the first one is the Department of Justice digital accessibility actions. Again, I have the don't wait sign because the DOJ, they're trying to get the regulations out for state and local government, but they're not waiting to enforce the ADA. And two recent things are in Oklahoma. Oklahoma had a mobile app that was used by citizens. I'm forgetting now what the purpose, something about identification, I think. And the Department of Justice investigated, wrote a letter, found Oklahoma in violation of the ADA. I have links to that in the links list as well from my website. And they did 4, and this is in the last year, 4 findings against Texas counties. Oklahoma was state, Texas counties, for not having accessible voting information. So the DOJ isn't waiting to enforce the ADA, to implement the ADA at the state and local government level. If you're in state and local government, you shouldn't be waiting either. Another one of my favorite cases, a California Parks website case illustrated by a person holding up money as a deck of cards on fire because there was an incredible, this is a procurement case. This is a really important case, and I want to give a shout out to Tim Elder, who started the case, and his colleagues and co-counsel. Michael Allen is one of them. It's a False Claims Act case. You cannot sell to a government, state or federal government in the United States, and make a false claim about it. Typically, a false claims case would be like an airline or a military contractor charging $10,000 for a toilet. But this was a very creative use of false claims to say this web developer said the website was going to be accessible, but it wasn't. They made a false claim about accessibility, and therefore the parks website wasn't accessible, was a potential $6 million website, didn't actually cost that much because it had to do with, sorry, going very fast, had to do with how many people were going to make reservations. Anyways, the case has now been resolved. The amount of resolution was close to $2 million, a little over, I think, $2 million that went partially to the blind person and partially back to the state. And most importantly, or equally importantly, an obligation to fix barriers. So, this idea of VPATs and legal requirements, take it seriously on both ends, on the delivering and the receiving end, because this was a bad situation that could have been avoided. In education, there's a lot happening in the higher ed space. That Los Angeles Community College District had a $240,000 verdict against it last year for discrimination against students in the digital space. The City University of New York in 2023 also did a settlement. There was a recent structured negotiation about continuing ed for lawyers not having captions. You can't try to teach anybody anything without captions. Really important. And there's a higher education accessibility lawsuit tracker I really recommend to everyone, especially those in higher ed, because you can look at the settlements and see, you can look at the settlements and take them as a roadmap for what you should be doing. Employment, there's a case against ADP that was filed and then went into structured negotiations to settle about workplace software that wasn't accessible. There's a case pending against Workday that was dismissed on AI tools for hiring. I want to say, I should have said this beginning, that Some of these cases I mentioned, I know the accessibility people in the companies, and I know they're committed. I know the companies are committed. And just because you hear that a company got a lawsuit doesn't mean, oh my God, take that company off your list to do business with or think poorly of. Yeah, sometimes there are bad actors, but a lot of times there can be strong teams. Many of you may be on them, as well as situations that end up in court. Kiosks, really important things happening in the kiosk space, even though we don't have the regulations. Quest Diagnostics and LabCorp have cases brought by the American Council of the Blind for checking kiosks in labs. CVS Health Hub has a lawsuit pending about the checking kiosks at CVS. I don't have time in this talk to talk about talking prescription labels, but I do want to give a shout out. CVS does have this kiosk case. They also last year worked in structured negotiation with the ACB, myself and others, to build the talking prescription app right into their mainstream app. The only pharmacy I know that has done that. I have a kiosk tracker on my website, keep track of all the legal issues around kiosks. I invite you to look at that. A lot of things happening in voting. Good case on VR captioning. First one I know of in the country where a VR library was required to have captions. Podcast case on transcripts is pending. National Association of the Deaf. It's very heavily litigated right now. I follow that on my website too. It's against SiriusXM. Do I have 2 minutes to talk about my least favorite parts? Can I have it? How are we doing on time?
We're doing well.
Okay, good. Then, okay, give me a 1 minute warning then, because my least favorite parts of the US landscape, which is dark, instead of beautiful fireworks, it's dark and stormy and cloudy. The numbers in 1 year, in 2023, there were 4,600 digital cases filed. There were 700 against defendants who had already been sued. 97% of the cases are about websites. Only 2% about mobile sites. 933 of the cases were about companies using an overlay. I get this information from UsableNet. It's an accessibility company. You can look it up online. I don't do my own verification of this, but I have no reason to doubt their methodology seems strong. I don't like the numbers because the numbers to me take the law out of civil rights, out of people, and create a lot of fear. So, I've been critiqued. I accept that. Sometimes after I do a talk, someone actually did a little video. I disagree with Lainey Feingold. The lawsuits matter because they motivate people. When they motivate people, I say good. I feel I have to share them because for those of you who are motivated by them, but too often they lead, in my view, to a view of people with disabilities as just in it for the money, just sitting in their room running a scan, not really caring about the accessibility. And that is so far from the truth. And there are so many ethical lawyers filing ethical cases, structured negotiations, good agency actions like we saw. So the numbers, not so much. We could do a whole talk on that. We will. Overlays and slap suits, strategic lawsuits against public participation. Not good. Which is why I have the Imperial Death March playing on this slide, because I have the Star Wars character. Okay, so there was a lawsuit against accessibility expert and my friend Adrian Rosselli by a company that does many things, including overlays, which was recently settled. I have an article about it on my site. Adrian has an article. Very concerning to see this kind of development in the accessibility space. There are 2 lawsuits pending in France by another overlay company called Facilite, 2 women-owned, one a single woman accessibility advocate, the other small women-owned business. So if you're not familiar with the overlay issue, I encourage you to look at the overlay fact sheet, overlayfactsheet.com. Again, that could be another whole 40 minutes. I also want to mention on this sad things I don't like website slide is that DQ, the sponsor of this incredible AXCON conference and an organization that has contributed to the testing space, they had to file a lawsuit, today's Tuesday. So last week, for theft of their intellectual property. So against a company called Browsers. I think it's okay. That means my time is up. Browser space. Anyways, I didn't, it's funny. I didn't put that on. I didn't put that on the, I didn't put the name of the case on the slide because sometimes people pull out a slide and it looks like, oh, Lainey thinks the lawsuit is the Darth Vader thing. No, I think it's sad that in the industry, a company like DQ has to file a lawsuit for theft of intellectual property. Okay, let's see if I can squeeze in one more thing. I don't think so. Oh yes, one last thing, the global landscape. The foundation globally is strong and growing. I keep track of, wrong. With the help of many in the community, I try to keep track of what's happening around the world. I have a global law and policy page. The link is lflegal.com, global-law-and-policy. It's right available from the top menu bar, navigation bar under legal updates. And you'll see in there not only what I know about the global law, but the contributions from more than 35 people around the world with their LinkedIn addresses. So we can help give you information about who knows this stuff, who's working in your country, who do you need to know about. So the biggest thing in the horizon is the European Accessibility Act, which is already starting in effect, full effect in 2025. Lots on the website about that. So I'm going to stop there for questions. If we don't have questions, I have some thoughts about how we talk about the law, but we'll leave that and see what the questions look like.
Awesome. Thank you so much, Lainey. Let's get into some of your questions. So first one here asks, are you seeing anything hinting at a backlash against disability rights similar to the anti-DEI legislation we're seeing in many states?
That's a good question. Well, in the state law, there is a law I call the Kansas Backlash Bill, which I took off because I knew I didn't have time for everything, but I should have put it on because, I feel part of my job in doing this work is to motivate us all to be able to put the law in our pocket and to see it for the good. So when I hear about a law in Kansas where it's backlash against the type of lawsuit that I don't like counting. So it's not really a backlash in the terrible way that the DEI backlash, that political disaster. I mean, disability is impacted whenever DEI goes. So there's that, but I haven't seen anything specific. There's no politics around digital accessibility the way there is the reactionary Republican politics around the DEI. So we don't have that. We do see some backlash because of the number of lawsuits and because of the unfairness that many in the small business community perceive. I share some of that as well, that these lawsuits aren't really about the fix. So we see some of that, but not, very good question, but not really in the same way as the DEI stuff.
Thank you. Meg here asks, you mentioned not waiting for laws to be passed to begin paving accessible pathways. Many of us are small departments or just a single person who often need to pull it's the law card to influence leadership. Do you have any suggestions on how we can convince leadership when we're waiting on laws to drop in the meantime?
Yes, that's very good. And sadly, I saw a great presentation on AxCon. I think that's happening right now about convincing organizations. So I bookmarked that so I can go back and see it. And I encourage all of us to. I have some ideas. That's really what the next section is. I start with the foundation and the strong laws because the law already requires. I think looking at what the Department of Justice is doing, looking at the ADA lawsuits, on my website, you can go back on that legal update tab has US laws as well as global, and the US laws, this tsunami of lawsuits started in 2017. And there were a lot more decisions then, and you can look at them and see what the ramifications have been. Now most of the cases settle. One of the reasons I don't like those cases is they usually don't settle for anything public. So we don't really know, are they really getting a fix in accessibility? But they're certainly, probably getting money. I have some strategies. I'll just give you the next slide. Don't be a shark when we're communicating about this stuff. This is why I have the Jaws theme song and the shark jumping out of the water with big teeth and the big X over it. Don't be a shark, be a dolphin instead. I know that's too short, but I do have a talk, accessibility convincing. And I think in my archives page, when people record the talks like this one, I link it to the archives page. So you could look for that.
Excellent. I think we have time for another question here too. This person asks, how might this recent ruling in Western Pennsylvania set a precedent for future cases involving the ADA and digital accessibility? Considering the dynamic nature of digital technology, do you see potential legislative responses or amendments to ADA that could further define its application to the digital realm?
Well, the Western Pennsylvania thing, like I said, it's not the first case to say that a web-only business doesn't get an ADA lawsuit. It's not the first case. It's just a case that happened this week. So in some circuits, like I said, you can have a web-only business. In 2012, the first web-only case was against Netflix. There was a lawsuit against Netflix. Netflix had to do captioning. Netflix doesn't have a store you walk into. So I don't think the technical legal precedent of a case in the Western District of Pennsylvania is only in the Western District of Pennsylvania. So if you're in that district, it's something, you can pay attention to. But I mean, I don't want to say don't pay attention, which is why I have like that big, legal advice here. But you're not going to build a website just for the Western District of Pennsylvania or for other circuits that say the ADA doesn't cover web-only businesses. In terms of clarity on the ADA, it's going to be there have been bills introduced. You can look on my website. There were bills introduced by Republicans a couple of years ago to deal with digital accessibility lawsuits, again, require notice, that kind of thing. I think first line is for the agencies to talk about what's covered. And these laws, the pending web accessibility law and the pending CVAA, like I said, they talk about emerging technology, not super strong. I mean, we got to figure out a way, and I invite any of you in the regulatory space to come up with ideas. These regulations have to be a little more evergreen. They've got to be based on principles in a way that, like you said, technology is always changing and the law is like walking through mud. So, yeah. And then there's politics. So that impacts what kind of laws and regulations and court decisions we get.
Absolutely. Well, Lainey, thank you so much for your presentation. Super informative and really impactful stuff.